Attorneys have slammed the Trump administration's practice of transferring detained students and scholars to remote ICE facilities in Louisiana and Texas. This tactic is allegedly designed to complicate their legal cases by placing them within conservative judicial districts. Columbia University's student Mahmoud Khalil's legal team was stunned when immigration judge Jamie Coleman's in Jena, Louisiana, announced she would rule on his deportation just 3 days after his initial court appearance. The compressed schedule provided minimal time to review evidence alleging the legal permanent resident posed a national security threat for leading pro-Palestinian demonstrations. This accelerated timeline has alarmed immigrant rights advocates, who accuse the administration of strategically isolating college students and professors in remote detention centers. These facilities fall under the jurisdiction of the Fifth Circuit Court of Appeals in New Orleans, widely regarded as the nation's most conservative circuit. They are for home shopping as to where they want the case decided. That has been clear, certainly in this case, and others in which individuals have been shipped off to a faraway location. Khalil isn't alone. Tufts University graduate student Rina Ozturk is detained at the same facility in Jena, a town of roughly 4,100 people. Harvard University researcher Sonia Petrova is held in Ridgewood, Louisiana, while Georgetown University researcher Badshah Khan Suri was transferred to Alvarado, Texas. All were transported hundreds of miles from their homes. Justice Department lawyers claim these transfers occurred due to insufficient space in ICE facilities closer to where the scholars were arrested. Nearly 40% of the approximately 48,000 immigrants in federal detention last month were held in Louisiana and Texas facilities, according to data analysis by Syracuse University. But federal Judge Denise Casper questioned this reasoning in Ostrak's case. She noted that when the Turkish national was arrested outside Boston, beds were available at an IC facility in Maine just 100 miles away. Even more troubling concerns. Attorney revealed that despite the government's bed space justification, her client is currently sleeping on a mattress in a common room at Texas Prairieland Detention Center because no beds are available. The detention centers in Louisiana, Texas, and Mississippi house 14 of the nation's 20 largest immigration facilities. Democratic and Republican administrations have long used them as immigrant detention hubs, but the rapid transport of recently arrested academics has intensified scrutiny of this practice. The administration's strategy is to isolate the individuals from their communities, their legal support, their families in hopes that media attention and mobilization around their cases dies down. Legal experts suggest another advantage for the government. Cases heard in Louisiana fall under the jurisdiction of the Fifth Circuit Court of Appeals, widely considered the most conservative in the country. Civil rights groups have also highlighted allegedly inhumane conditions at Louisiana facilities. A recent 88-page report titled Inside the Black Hole described unsanitary food and water, medical neglect, and physical abuse inside these detention centers. Meanwhile, a federal judge has upheld a Trump-era policy allowing ICE to conduct enforcement operations at churches and other places of worship, rejecting a lawsuit from over 24 Christian and Jewish groups who argued it infringes on religious freedom and discouraged attendance. Judge Dabney Friedrich, a Trump appointee, ruled there was little evidence ICE was specifically targeting religious sites or that the policy shift directly caused the drop in attendance. That evidence suggests that congregants are staying home to avoid encountering ICE in their own neighborhoods, not because churches or synagogues are locations of elevated risk. The policy enacted on Trump's first day back in office scrapped an Obama-era guideline that had limited ICE actions in sensitive locations like schools and churches. Drawing criticism from faith leaders who say it breaks with decades of precedent meant to shield vulnerable communities, that a Louisiana immigration judge has ruled that Columbia University graduate Mahmoud Khalil can be deported after the United States government argued his presence posed potentially serious foreign policy consequences. Assistant Chief Immigration Judge Jamie Cummins based her decision on evidence submitted just days earlier, including a memo from Secretary of State Marco Rubio. This memo alleged Khalil is deportable because of beliefs, statements, or associations that would compromise U.S. foreign policy interests, despite the government's failure to prove that Mahmoud broke any law. The court has decided that lawful permanent residents can have their status revoked for pro-Palestine advocacy. This is a blatant violation of the First Amendment and a dangerous precedent for anyone who believes in free speech and political expression. Khalil was arrested last month outside his Columbia University apartment following a deportation order from the Trump administration, as a prominent Palestinian activist who played a central role in protests against Israel's war in Gaza. His lawyers contend he is being targeted for his pro-Palestine activism. At the hearing's conclusion, Khalil addressed the court directly. Neither of these principals were present today or in this whole process. This is exactly why the Trump administration has sent me to this court 1,000 miles away from my family. On April 11th, President Trump announced a dramatic plan to transform a narrow strip along the Mexican border in California, Arizona, and New Mexico into a military installation as part of his effort to curtail illegal crossings. The White House memorandum calls for transferring authority over the 60-foot wide strip of federal borderland known as the Roosevelt Reservation from other cabinet agencies to the Defense Department. This would allow military forces to temporarily detain migrants for trespassing on a military reservation. The directive expands a military presence that has already increased steadily along the southern border, despite crossings having dropped drastically during the Trump administration. The ordering of troops to the border has placed the military in politically charged territory. According to the memorandum, the border strip will become a military installation under the jurisdiction of the Pentagon. Military personnel would be able to stop anyone crossing into this installation, but would not have the power to make immigration arrests. Border Patrol agents would then be summoned to formally arrest the migrants. A section of the memorandum calls for authorizing state National Guard members to work on the military-controlled strip. If those working at the installation hold migrants until Customs and Border Protection officials pick them up, their use comes very close to military personnel detaining migrants. This directive formalizes a plan the administration had been considering for weeks, adding yet another layer to the Trump administration's increasingly aggressive immigration enforcement strategy.